Well, hello, and welcome back to another exciting edition of Coffee with Stephen. This week's blog has to do with a court case that was just recently handed down by the California Court of Appeals. It's Alvin et al. Versus Becerra. And candidly, I'm going to be honest with you, it probably doesn't directly affect you. However, there are some potentially far-reaching implications of this case, and whenever whenever justice and freedom are able to be victorious over the hands of tyranny, we want to pause and we want to raise our glasses in a toast to say hoorah. Anyways, give you the basis of this case. The legislature crafted a rule that all of you are all too familiar with in California, stating that you can only purchase one handgun every 30 days. Now, there's some exemptions to that rule. One of those exemptions is that you're doing a private party transfer. If you're buying someone's collection of firearms, you don't have to wait every 30 days to get the next gun. The other exemption states that if you have an FFL as well as a certificate of eligibility, now it's a little wonkish here, but effectively you're not on the centralized dealer list, but you do possess an FFL and you have a certificate of eligibility, that also creates an exemption. Well, back in 2014, there were a couple of individuals that had FFLs specifically designed for what are called curios and relics. These are collector FFLs, for lack of a better term, for people that are buying weapons that essentially are historical antiques or have some unique feature associated with them. In any event, they asked for a declaration by the attorney generals essentially saying, hey, according to the law, it says that as long as you have an FFL, which we do, granted not one that normal people would recognize, and we have a certificate of eligibility, which we do, we should be exempt from the one gun a month, even though the FFL in question isn't specified towards that one gun. Well, the Attorney General basically said, screw you. We're going to interpret the law to essentially mean that if the FFL wouldn't cover the underlying transaction, we're not going to allow it to happen. So they sued, and they lost at the district level. As it made its way up to the Court of Appeals, the Court of Appeals did two things. Number one, they agreed with the plaintiffs. They have now been given declaratory relief. They are allowed to purchase more than one handgun a month. That exemption exists. But more importantly, the court took to task the Department of Justice, essentially saying, you are not the ones who get to interpret the law. It's the courts that interpret the law. This has potentially far-reaching implications, especially those of you who are currently looking at the assault weapons ban. In any event, take a look at the blog. Some of you may look at it and go, why the hell is he writing about this? Well, if for no other reason, the fact that, like I said, freedom wins over tyranny is always something that we want to acknowledge. As always, I want you to train constantly, train consistently, train with purpose, and above all else, stay vigilant. Until next week when we have coffee again together, thank you for watching our podcast or our video cast.